All right, let's move on. Management of an escrow account. Very, very important section here. This comes out of Unit 5, Real Estate Brokerage Activity and Procedures. You got 12 questions, okay? Now, a couple terms you want to know. You want to know, and I'm just going to kind of pick these out that are real important for the state exam. You want to know commingling and conversion, C and D. Commingling is mixing, right? Conversion is when you use it to cover expenses, for example, okay? In the escrow account, for the sales escrow account, this is the broker's account, by the way. This isn't a sales, this is only for the broker. For a sales escrow account, the broker can keep a maximum of $1,000 of personal money in there. Property management, $5,000 is the maximum of personal money. You say, well, John, I thought we couldn't keep. That would be commingling. No, the law says the broker can keep $1,000 of personal money and $5,000 of personal money in these escrow accounts to manage them. The last thing you want to do is use somebody's deposit to pay an account fee. That would be a violation of licensing law. So the broker has to have personal money in the account to maintain the account. The restriction is $1,000 for sales and $5,000 for property management. If they're using one account to do both services, they can have $5,000. Okay. Now, record keeping is 5 years. If the title company is going to keep the deposit, they have to have their name, address, and telephone number of the attorney or title company on the agreement. Okay. Now, you got two types of accounts. You got non-bearing interest account and interest-bearing accounts. Okay. Non-bearing interest accounts or non-interest bearing are typical for real estate transactions, right? It's just like burying it in the backyard. It's an account that doesn't do anything but hold money until the closing. It's the buyer's deposit, and that's where it goes. The broker holds that deposit, okay, in their escrow account. They can have an interest-bearing account, okay? But if money is going to be moved, listen to me carefully. If they're going to move money from a non-bearing interest account to a bearing interest account, all parties have to agree in writing, okay? Two types of accounts. Non-bearing interest, which means it don't earn interest. Bearing interest means it can earn interest. So, well, John, why would you want to have a bearing interest account when the real estate transaction is only 30 days and it's a $2,000? How much interest are you going to collect? That's a good point. And typically residential, everything gets deposited into a non-bearing interest account. But interest-bearing account can come, say, in a commercial deal where you got a $3 million building that's being sold. It's going to take a year and a half. Now you got a different story if you're collecting a $30,000 down payment. Okay. But the point for the state exam is if you're going to move money or move funds from a non-bearing interest to a bearing interest, all parties need to know in writing. Okay. All right. Which statement is true regarding a real estate broker who provides property management services? What do you think? Which statement is true? Okay. Again, if you go through this and you're looking for one true and three false, right? Looking for one true and three false, talking about property management services. So it's kind of a generic question. So I don't have any answers I can come up with, but I'm going to read the questions. I'm going to read each answer and convert it to a question. So brokers are allowed to keep up to $5,000 of personal in a PM escrow account, property management. And I know that to be true. So my first answer is true, but I'm going to make sure sales associates are allowed by law to independently provide property management services to absentee owners as extra income. That's false. Brokers required to maintain a separate property management escrow account. No. Brokers may post a bond with the county court in lieu of. No. These other answers usually come under the Florida Landlord and Tenant Act. Okay, when the landlord has laws, they have to keep escrow money like security deposit and rents. But what we know from our studies here is the maximum for a property management account is $5,000. Okay, so we're talking about answer A. Very good. Looks like everybody's on board there. Perfect. All right. Let's talk about business entities that do not need to register with DBPR. Remember, the business entities that have to register with DBPR is general partnership, is limited partnership, corporation, LLCs, okay, limited liability partnership, LLPs. The ones that do not need to register with DBPR is corporation sole, and they like to ask the question about joint venture. Joint venture is only when two licensees come together to do one single business activity, and then they're gone. Okay, so it may be a condominium, new construction, perhaps with a marina, and so a broker has experience with marina sales with condominiums, and then the other broker has condominium, and they want to come together for a single project. And when these condos are sold, boom, they go away. So it doesn't have to be registered with DBPR if it's only for a single business activity. If they form a general partnership, if they form a limited partnership or a corporation, they got to register with DBPR. Okay. So corporation sole, like church office, joint venture, business trust, co-op association, unincorporated, like HOA committees that get together and do landscaping or beautification. These are a few that you want to know. They like to ask joint venture. Joint venture seems to be, because that's usually what's typically involved with real estate brokers. They get together in one project, one business activity. Once it's done, then it's gone. So there's no need to register with DBPR. Okay. All right. A joint venture usually is created to what? Good. Excellent. Right? Carry out a single project, okay? Activity. Don't have to register that with DBPR. Very good. All right. In chapter 5, one of the biggest sections here, right? 12 questions. Real estate brokerage activities and procedures. Okay, so we're going to go back and look at the process for disciplinary action after a complaint process. Remember, the complaint is filed. Anybody can file a complaint against the licensee. Okay, must be in writing, and obviously it's got to be signed by DBPR. It's got to be a violation against the licensee about licensing law. So the licensee have had to violate a licensing law statute. Okay, a 475 statute. Now, here's where the investigation starts. And we talked about this a little bit earlier. The complaint comes in writing. DBPR is processing it. They're going to determine what the allegation is, and then they're going to start investigating it. Okay. Remember, DBPR will send a copy of the complaint to the licensee or the attorney representing the licensee. Okay. So the copy of the complaint's got to go to the licensee as well. Now, here's what you have to know. Summary suspension. Summary suspension is issued by the DBPR secretary only, okay, the DBPR secretary only, when the licensee is determined to be a public danger, okay, or the complaint is so egregious that the DBPR, again, secretary is going to summary suspend or suspend temporarily until the actual process is over, complaint process is over, okay? DBPR secretary only can issue a summary suspension. Now, and we talked about this earlier when we were talking about the probable cause panel. Remember, 2-member panel. It's got to be an active current member, okay? Whether it's a whether it's a broker, a sales associate, a broker associate, or a non-licensee. It's got to be a current, and it can be a former, but they got to be active. Now, one of the two has to be an active licensee. Okay. All right. So sufficient complaint, then it's forwarded to the probable cause panel. So DBPR makes the decision. Remember, they could stop there and just issue the initial complaint, the first time complaint, or they can forward it to the PCB panel to further the investigation. Remember, the PCB panel is kind of a balance of powers. Let us take a look at it now. As licensees, let us take a look at it. And if we see deemed to go forward, we'll move it forward. If not, we're going to stop it here and do what we have to do. Okay. So sufficient complaint, DBPR says we're going to forward it to the probable cause panel. All right. If a legally sufficient complaint has been filed, investigated, and found valid, the next step in the complaint process is what? Good. Perfect. Don't forget the summary suspension. That's kind of a sidebar. Okay. They like to sneak a question in there, and they'll put all kind of answers in there that make sense, but who can be the only one to suspend the licensee under investigation in the beginning of the process? And it's the DBPR secretary, and it's called the summary suspension. Okay. All right. So if a legally sufficient complaint has been filed, investigated, and found valid, the next step in the complaint process is probable cause determination. Okay. Remember, we're talking about the complaint. So this is the initial stages. It's been filed. They're investigated, DBPR investigated, and found it valid to go on and continue. They're going to forward it to the probable cause panel. Now, you can see that there's those other A, B, and C. Those are actually correct answers in the process of the formal complaint. Remember, after the probable cause panel determines it needs to go further, they will issue a formal complaint to the licensee, and the licensee has 21 days, called the election of rights, to choose to have an informal hearing or a formal hearing. Okay. And then after the determination has been made, a final order issuance is given, and then they can go in with the final order issuance, and then the licensee can go into the appeal process. Okay. Because the actual final order does not go into effect for 30 days, and that's the appeal window. So we're talking about probable cause determination. Good.
For more practice questions, videos, and insight into the state exam, we encourage you to join our free webinar, How to Pass the Real Estate Exam Without Your Real Estate Book and with only 15 to 20 hours of study time. Get registered now at myrealestatetutor.com/exam.